Madam Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction on appeal from the Court of Appeal of Barbados. Hearing of appeal in CCJ Appeal BBCV number 1 of 2021 between Richard Boyce and others and Jedder Ferneaux Robinson and the Commissioner of Police, the Protective Services Commission, and the Attorney General. The members of this morning's panel are Mr. Justice Saunders, President and the Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Mr. Justice Anderson.
Good morning, Counsel.
Good morning, Your Honor.
Mr. Justice Varro.
Good morning, Counsel.
And Mr. Justice Jamada.
Good morning, everyone.
May we have the appearances, please? Thank you.
Court. My name is Ralph Thorne, and I appear in association with Mr. Harlow Boones for the several appellants.
Yes. Good morning again, Councilman.
Great, please the court. My name is Ms. Donna Brathwaite, and I appear in association with Mr. Jared Richards on behalf of the respondents in this matter.
Yes, good morning again, Mr. Brathwaite. Okay, we have seen the draft order that has been proposed. Ms. Brathwaite, would you like to speak to it?
Yes, Your Honor. In respect of the draft order, we received it this morning and we actually had some proposed amendments to it. And with the court's permission, we've sent it electronically to Learning Council on the other side quite recently. And if I could proceed and let all parties hear our proposed amendments.
Speaking for myself, I don't know that it is necessary. Commendably, the parties have embarked on a process of settling this matter by a consent order. We would be prepared to give you a reasonable time to resubmit a final draft of this order. There's something which I would like to probe a little bit. The memorandum that is referred to in the draft which we have, is that memorandum to be submitted with the draft?
To the best of my knowledge, and Mr. Thorne can confirm, I do not believe it's to be submitted.
Okay, well, put it another way. I take it that you would you would intend for that memorandum to be a confidential document.
Yes, Your Honor.
Okay. What I'm trying to work out is if, and that's fine, the parties can have a confidential settlement of the matter. We would want that both sides sign that memorandum, actually, and if you're not disposed to having the court have and retain a confidential copy, then at least you would each exchange original copies so that in the event that something comes up and it is necessary to proceed to enforcement, that there isn't a difficulty being able to establish the bona fides, the authenticity of the memorandum concerned.
Yes, Your Honor. We have no issue with that. I believe Mr. Thorne is on mute. I heard him talking, but I think he's on mute. I don't know if he wanted to say something.
Yes, just for the record, I want to outline that Mr. Justice Anderson is very much present with us, but is having a little challenge with
Oh,
Okay.
he said no.
He's there.
His visits now appears, President.
Yes. Okay. Great. Yes, Mr. Thorne.
Yes, thank you, Your Honor. Our position is that while the court uses the language of confidentiality in relation to the document, we would definitely wish the court to have sight of that document and for that document to become a record accompanying the order. Secondly, I wish to indicate that I drafted the order just this morning, and as a matter of courtesy, I'm constrained to say to the court that it happened only this morning because of the circumstances. And the circumstances are that the Attorney General agreed only yesterday afternoon to the content of the order. And therefore we were forced to do that as a matter of haste this morning. So I feel constrained to explain this to the court, since in all the circumstances we are late, but we are late because of those peculiar circumstances.
Yes, I understand, and that's not a difficulty with us. What I would suggest is that we give you, the parties, until maybe the 17th, another week, to submit. And I agree with you, Ms. Raff, that it is preferable that the court should keep on the confidential cover, of course, a copy of that memorandum. Of course, it wouldn't be on our website. It would be disclosed to anyone else. But I think that is the more appropriate step to take. So we can give you until the 17th to submit the draft order, and perhaps submit by email rather than through the court's filing system the memorandum, which would be a form of appendix to the order. And we will convert that draft into the definitive order of the court and send it back to you.
Your Honor, if I may, if in the event that we don't agree to the precise content of the order, where does that leave us in relation to a court? We don't wish to come back to a court in disagreement. I am wondering if Ms. Brathwaite may not submit her order and we submit ours, and let the court resolve the difficulty, because based on a conversation I had with Ms. Brathwaite within the last 15 minutes, there may still be some contention, and we hate to come to the court with that contention. So I would prefer to refer these two orders to the court and let the court give its final ruling in that regard.
Yeah, but wait. We couldn't impose an agreement on you for that. Agreement is either a mutually acceptable contract.
There's one.
I think President Mr. Thorne is proposing to make you the mediator in terms of finalizing an order. And I think his confidence in you, while a matter of high regard, may be a bit embarrassing for you.
Listen, Mr. Thorne.
Yes,
it's fine if you and the other side wish to have some reasonable time to hammer out this thing. Of course, if there is complete agreement that the respondents are have admitted liability, and it is a question of the quantum of the judgment and or the form in which the damages should take, then one can deal with that as a separate proceeding. But let us take it step by step. How much time do you both need in order to hopefully conclude the discussions, or at least to be able to determine what has been agreed definitively and what is left outstanding?
Your Honor, 7 days is sufficient time for us.
Okay. So we wouldn't adjourn to the 17th. What we would do is to give you until the 17th to indicate to the court what is the current position. If you are agreed on all the issues, then it's a formality for the court to simply endorse your agreement. If it turns out that you are agreed on some issues, for example, liability, for example, I don't know, but if you agreed on some issues and you are not agreed on other issues, then you would let us know. And then at that point, we will inform you how we propose to address those matters on which you are not agreed.
President, if I may, I am now looking at the draft order on my phone, and the registrar has kindly advised me to not show my phone, but since it is the draft order, I think I can show it. I'm just seeing it now. I was working on another matter and had not looked at it, but it seems to me that where we are is that the parties have agreed that this case is settled, and therefore it seems to me we can order that by consent, the respondent no longer contesting this appeal, judgment is entered for damages, the quantum of which is to be determined, is to be agreed or otherwise determined. But I think putting the appeal to an end by saying that judgment is entered is what the parties need at this stage. And I would therefore offer that thought.
Yes. Ms. Prophet, do you have a difficulty with that, with us formally?
Yes, yes, Your Honor. We had a bit of difficulty with that phraseology. That's why we had sent to Mr. Thorne this morning some proposed change of wording. So that is why what is on Your Honor's telephone is different from what we proposed.
Maybe, Ms. Lambert, could you just tell me for my own edification, what would be the variation in terms of the disposition? We know damages are to be worked out, but it seems to me that you have agreed upon a disposition. What is the disposition that you think you have agreed to?
Yes, we were proposing that the respondents, this is the first paragraph, that the respondents no longer contest this appeal and agree to pay to the appellants damages and costs in such amounts as agreed by memorandum between the third respondent for and on behalf of the three respondents and for Mr. Ralph A. Thorne QC on behalf of the
Sorry, Counsel, let me stop you there. My suggestion is that you are agreed on the first part. It seems to me, sorry, from what you are saying, that you are agreed that the respondents no longer contest this appeal and agree to judgment. Sorry?
And agree to pay to the appellants.
As what?
And agree to pay to the appellants, damages and costs.
Okay, damages, yeah. Damages to...
We weren't having the words to judgment for the appellants.
Sorry, you want to take that out or put it in?
We wanted to take that out. So we would just have that the respondents no longer contest this appeal and agree to pay the appellants damages and costs.
Okay.
And is it that your position is agreed as by memorandum and in default that it will come to a court for assessment? In other words, what you are agreeing to is that they're not going to contest this appeal and you pay damages and costs as such amounts agreed, etc. But if there is no agreement, what?
That was not contemplated at all in the consent order, because the what we were being told was that the parties had in fact reached some agreement. Was a memorandum which will be sent to the court on the confidential cover actually states the sums each appellant would be getting.
Okay, I think we are clear on one thing, that the respondents admit liability and admit and agree to pay to the appellants damages in costs. What is still up in the air is the expression of the damages and costs in a memorandum. So what we can do this morning is to enter judgment for the appellants by an order by consent that the respondents no longer contest this appeal and agree to pay to the appellants damages in costs. And we can also order that the parties to provide to the court by the 17th of December on the confidential cover a memorandum reflecting the payment, we'd have to refine these words. I'm just thinking as I speak, reflecting the quantum and the method by which the damages are to be paid. And allow for liberty to apply. If by the 17th there is no memorandum or there's disagreement on the memorandum, then the court will have to bring the parties back and or issue an order for some procedure to be followed for arriving at that issue. I wouldn't want to prejudge how we would deal with it, but let's take it step by step. But it seems to me that that is where we are at this time.
But is it that the respondents admit liability, or are you just saying, well, if we have to pay an amount X, then we will no longer contest this, which is somewhat different?
Your Honor, that is more of the thinking that we've decided to settle it out of court. And what Your Honor is saying, I thought that was more the line that we were trying to take, as opposed to saying accepting liability or having a judgment entered.
And may I say, that sounds as if it was my understanding as well. And what the president of the court put on the table initially sounds to me to be perfectly reasonable. That is to say, the both parties seek to work out the terms of the order within a week, and then we see where we are. President, I thought that first approach was perfectly commendable.
Yeah.
Thanks.
Sure.
Yes, Your Honor.
Mr. Thorne, are you up with that?
Good. Go ahead.
I am happy, Your Honors, and let us all meet the court with complete candor and disclose further that these damages are agreed. The general damages are agreed. The loss of income is agreed in relation to 11 of the persons. There are 3 in respect of whom it is not agreed, and that's because they've retired. Their files are out of the system, and that is the only matter left for resolution at this point in time.
That makes it easier, Mr. Thorne, doesn't it?
Indeed, my Lord. Indeed, Your Honor.
Thank you.
Indeed.
Okay. Okay. So coming out of today's hearing, the court would issue an order that, in your words, that the respondents no longer contest this appeal, ordered by consent, that the respondents no longer contest this appeal and agree to pay to the appellants damages and costs in such amounts as shall be agreed by memorandum among the parties. That said memorandum is to be provided to the court on the confidential cover on or before 17th December. And thirdly, there shall be liberty to apply it.
Your Honor, just so that we are absolutely certain, it's the language that judgment is to be entered Included or excluded?
Excluded.
We don't need to get hung up on that issue. If there is an order by consent that respondents no longer contest this appeal, don't kill the lily, Mr. Thorne. They are no longer contesting your appeal. You have appealed. They're not contesting it. They're agreeing to pay you damages and costs, so that that is definitive. That after today's hearing.
Mr. Thorne, if I may ride on the president's coattails, it seems to me that if they no longer contest this appeal, then the judgment from which they are appealing stands.
But that is the problem. The judgment was originally in their favor.
Yes.
I see.
Yeah, but you see,
was originally in their favor.
Yeah, but you have appealed and they're not contesting the appeal. So in effect, when you say we don't like that judgment for ABC, you're throwing up their hands and saying, okay, we're not contesting that. That is the effect of what
I see your point, Mr. Thorne.
Yes, if they're not contesting, they cannot be allowed to keep the secret that they're conceding on the judgment at this level.
But they are also agreeing. Not only are they saying that they're not contesting the appeal, they are also agreeing explicitly to pay to you damages and costs.
Yes, Your Honor.
I was wondering whether there's any chance that you would take yes for an answer.
Well, it depends on the question, Your Honor.
Whether your clients will get the damages that they want.
Yes, well, that is our major concern. That is our major concern, that our client shall receive payment. But we were just wondering why they're afraid to use the word judgment.
President, may I just say that if we put it off to the 17th for them to tidy it up, I think the point that has arisen is something that they should put a little attention on, which is what will the record show at the end? It may be that if you keep everything off the books, then the record that exists will show that, from a jurisprudential point of view, is that what we want to show that in this matter, actually, the appellant is on the record the losing party. So I don't know if, for example, an order that is often made is something as simple as appeal allowed, terms agreed on counsel's brief, and that's all that in litigation, that's all you need. That is a very acceptable convention. It preserves the record that in this matter, the appeal was allowed, with Mr. Thorne for the record, maybe, and for, as Solicitor General, for you, for the record is important, but the terms are agreed on counsel's brief. That is well accepted and used throughout as an instrument that legitimizes the record and preserves the privacy or negotiations of the parties.
No, the order is not going to be confidential, only the memorandum.
All right. Okay. So that the contemplated order is that the appeal be allowed.
That is my understanding.
Fair enough. I forgive me. I misunderstood.
Well, let me just make sure that I did not misunderstand myself. Mr. Thorne and Mr. Graffett, am I correct that the order is going to be that only the memorandum is going to be confidential?
Yes, Your Honor, that the memorandum will be confidential, except that it will become a part of the court's record. And yes, as your brother Justice indicated, that we believe that jurisprudentially the matter is worthy of resolution, and that it is only properly resolved to reflect that the other side has indicated to the court that they're no longer contesting the matter, and apart from not contesting the matter, they're conceding.
Therefore, Mr. Thorne, if the appeal is allowed, that disposes of the litigation.
It does indeed, Your Honor. Yeah. It does indeed, to say that the appeal is allowed.
Yes.
Yes.
Would that satisfy you,
and Solicitor General, we don't have to say judgment is entered.
No.
The appeal is
all you need to say is appeal allowed on terms agreed as per attached memorandum, council's brief. It doesn't matter.
Yes, we will accept that, Your Honor. I think that would.
General, will you accept that?
Yes, Your Honor.
Your Honor, we can agree to maybe a phraseology like settled in terms of council's brief, as Your Honor Jamadar.
The thing is, if you simply say settled in terms of council's brief, the record will reflect what?
Sorry, Ms. Bradford, the precedent or the precedent phrase is the appeal is allowed. No?
There is nothing about that injures the Attorney General's reputation in this case. Is there?
If you're paying damages, it has to be on the basis that you accept an obligation to pay without necessarily conceding the points at law or whatever. So they are appealing and seeking money, and you are agreeing, okay, you shall have money.
Yeah, but there might be an issue of the presidential importance of the decision. I assume the parties could settle out of court. And it seems to me that essentially is what they're doing. So that I think, I go back to what the president said, it's a matter of how the parties choose to phrase the settlement. And I would be quite happy to give them the time to seek to find the appropriate phrase. I'm sure they'll be helped by what has been said this morning. But ultimately, I gather it is the parties who are settling the matter. And I don't see any reason why they can't choose a phrase which best reflects their understanding of the settlement.
My brother, being last in practice after you, I think I'm more familiar with the disposition of counsel and the ability of counsel to find gaps and crevices in the platform upon which they are agreed. So I think what we are trying to do is to get it to the point where there is today a disposition of this appeal. That is the only reason why I am pushing in this regard.
Right. Yes. And as I said, I'm sure that they will be assisted by what has been said.
And I wonder, Your Honors, if it would assist the court in knowing that the journey towards resolution was initiated by the other side. And perhaps it helps the court to understand, to know that.
Well,
that we were quite clear to what we said.
It is one of the reasons why I'm not clear, Mr. Thorne, why you are so insistent on gilding the lily. You are going to get your damages, you're going to get your costs. Why can't you simply live with the burden that they wish to have?
Exactly.
Your Honor, there is the jurisprudence at stake, and
what jurisprudence? Then you're going to get your damages and costs.
There has been no hearing. There has been no reasoned judgment. The parties, as I understand it, are seeking to settle the matter, in a sense, out of court. So, as the president said, I'm not quite sure what the jurisprudential value of the phraseology would be.
Well, Your Honors, we will let the other side say on what basis they are paying damages, whether they're being friendly or whether they're accepting liability.
I am sure your clients, and I'm sure I could put my head on a block for that.
They're
Your
not
clients
concerned.
have not the slightest interest.
Absolutely not.
In all of that. They are simply concerned to get the damages they think they're entitled to. Don't you think so, Mr. Thorne?
Oh, yes. The clients could be happier, but they're happy.
You know,
they could always be more happy.
Listen, if there can be agreement on the precise words today, we would defer that as well. So come back on the 17th, order, and a memorandum sent on the confidential cover, and we will take it from there. So,
as the court pleases.
Yes. The order for today is that the matter is stood down pending the parties' agreement to submit to the court a draft order settling this matter. And that is to be done by Friday the 17th.
It would seem to me that theoretically there are two ways of ending this, either by a consent order or appellants withdraw the appeal after having been paid what has been promised. That's another method of dealing with it. So up to the parties to decide what way they want to go.
Yes, so effectively we would give you until the 17th to provide us with hopefully a definitive settlement of this matter, terms of settlement of this matter, and then we will take it from there. There would not be a hearing on the 17th. We would just expect you to provide that documentation. The court will review it, and if it becomes necessary for us to reconvene, we would let you know when that would be. More than likely it would be sometime in the new year.
As the court pleases.
Yes. Ms. Prophet, are you good?
As the court pleases. As the court pleases.
Okay. Madam Deputy Registrar, can you close the proceedings?
Thank you, Mr. Justice Saunders. Thank you, Mr. Justice Witt. Thank you, Mr. Justice Anderson. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all, and do have a very safe weekend. Thank you.
Thank you.
Thank you.